welcome back to my channel. So today I will dictate a dictation of about 400 words in 80 word per minute. So start. The appeal was dismissed by the learned additional sessions judge, Southeast Saket Courts, New Delhi, wide order dated 25th March 2012. Thereafter, the appellants, after expiry of 3 weeks, filed second application under Section 438 CRPC, which came to be considered by the learned additional sessions judge to Southeast New Delhi, who allowed the same by the impugned order dated 10th March 2012. The aforesaid order was assailed before the High Court on two grounds. First, the accused persons had misrepresented the facts and that there was no change in the circumstances, and second, the application for grant of anticipatory bail could not have been entertained by the learned additional sessions judge for the first application was rejected by the learned additional sessions judge 6 Southeast Saket. The High Court referred to certain decisions with regard to the parameters for grant of anticipatory bail, absence of charge of circumstances, conduct of the accused persons in the manner in which they had executed the agreement for sale, the need for custodial interrogation, and the impropriety in view of the fact that another court had entertained the application for consideration despite the fact that the first application was earlier rejected by another court, and analyzing these aspects set aside the order for grant of bail. It is necessary to state here that the High Court has drawn a distinction between an order passed which is perverse in nature, inviting the wrath of impropriety, and a cancelling order of bail due to supervising circumstances after the grant of bail. We have heard the learned senior counsel for the appellants, learned ACASG for the state of NCT of Delhi, and the learned counsel for the informant, the second respondent. On a perusal of the order passed by the High Court, we find that it has felt disturbed that the second application under Section 438 CRPC was allowed by another additional sessions judge who had not dealt with the first application. It has opined that the second judge could not have entertained the bail application, especially when the earlier judge was available. To elaborate, the additional sessions judge who has dealt with the matter on the first occasion had neither been transferred from the said court nor had he become incapacitated to come to court. As it appears, the High Court has taken exception to the fact that the application was moved when the second judge was allotted the roster to deal with the application under Section 438 CRPC. To appreciate the analysis made by the High Court, we have bestowed our anxious consideration and perused the order impugned. As far as the distinction drawn by the High Court passed in a perverse manner, excluding the relevant matters and considering the extraneous matters, which deserves to be lancinated in exercise of supervisory jurisdiction to nullify the same, and the other, which is fundamentally and absolutely situation based for cancelling the order of bail because of violation of the terms and conditions of the order granting bail and other supervising circumstances. However, the said situation or circumstance does not arise in the case at hand. In that context, this court held that long standing convention and judicial discipline requires bail application to be placed before the learned judge who had passed earlier orders. On a perusal of the aforesaid authorities, it is clear to us that the learned judge who has declined to entertain the prayer for grant of bail, if available, should hear the second bail application or the successive bail applications. It is in consonance with the principle of judicial decorum, discipline, and propriety. Needless to say, unless such principle is adhered to, there is enormous possibility of forum shopping, which has no sanction in law and definitely has no sanctity. These appeals have been preferred against the orders passed by the division bench of the Punjab and Haryana High Court at Chandigarh. The appellants in special leave petition of 2012 are the Chandigarh administration and the Government Medical College and Hospital, Chandigarh. The appellant has filed the special leave petition with the permission of this court, who was not a party either before the single judge or before the division bench of the Punjab and Haryana High Court. Leave to file special leave petition was granted in considering the grievance expressed by the said appellant, contending that in the event of the impugned orders of the division bench being implemented, her chance of getting admission to the course of MBBS for the academic year 2014-15 under the non-resident India category would be impugned. The present impugned orders of the division bench came to be passed. Stop.